May I have your appearances, please? Your name, sir?
Michael
Southport.
Sigatura, Michael Sigatura with Southport Apartments.
And Mr. Corridor, state your name for the record.
Cyril Corridor.
And Ms. Corridor.
Ashley Corridor.
Thank you. Today is the day and time set for the trial in this matter. We were here back on November the 16th. There have been documents that had been submitted by the plaintiff that the court had not received as of yet. We have since received those pictures and documents. Mr. and Mrs., Mr. and Miss, is it Miss and Mr. and Mrs.?
Yes.
Yes,
Corridor,
ma'am.
have you, did you also receive the documents from Southport?
Yes, we did.
Okay, and this court has received a video from the corridors. Mr. Segatura, did you also receive that video?
I did not get a video.
Okay. Let's see. When we get to, trying to think, I don't know which one of you sent it to the civil department. Mr. Corridor or Mrs. Corridor?
It was me. It was Ashley Corridor.
Okay, when we get to your part of the case, I'm going to ask you to share your screen so you can play the video. Do you know
Sure.
how to do that? Okay,
I believe so.
okay. Other than the video, did you, either corridor submit anything else?
No, that was it.
Okay, Mr. Segatora, are you ready to proceed on behalf of Southport?
Yes, Your Honor.
And we discussed this last time that you are a full-time employee of Southport authorized by them to be here this afternoon?
Yes.
Okay, and Cyril Corridor, are you ready to proceed this afternoon?
Yes.
Ashley Corridor, are you ready to proceed this afternoon?
Yes.
Thank you. This is a claim from Southport for $1,146.55 for damages due to the apartment and rent. The small claims affidavit also indicates that the apartment is located in Belleville. Mr. Segatura, please proceed with your claim.
Okay, I'll start with the rent portion. We have a rent balance due of $60.58. That's to cover 2 days of rent to complete their notice to vacate. They provided a notice to vacate on May the 6th. And per that date, they were responsible for rent through July the 4th. A letter was provided to them in response to that notice to vacate, letting them know there would be an additional $60.58 due after move out. That's the only rent portion. Again, $60.58 for 2 days of rent. The rest of the claim is for damages to the unit. We charged a fee to replace the damaged stove at $375.24. Our painter had to do an additional 3 coats of paint throughout the apartment to cover stains on the walls to the tune of $200. And then we had to replace the carpet throughout the apartment due to heavy staining throughout at a cost of $510.73. The cost on the carpet is prorated down based on the age of that carpet. Should have a copy of the invoice for the carpet, shows $921.47. And again, we're holding the corridors responsible for $510 of that $921. We do prorate the carpet based on its age. Basically, we depreciate the cost 1% per month that the carpet was in the unit. None of these items had any pre-existing issues. The photos show the staining to the carpet and the walls and the excessive burning, or I'm not sure what to call it, on the stovetop that had to be replaced, basically to get the unit back into a rentable condition. The stove, obviously, if you look at the photos, we can't rent an apartment with a stove in that kind of condition. Cost for the painting, again, is additional painting that our contractor had to do over and above a normal painting that we would do in between residents. His invoice shows three coats were needed, and that's extra $200 that's being charged. So those are the charges that I have, or the charges we're holding them responsible for. Their security deposit of $500 is being held in lieu of the outcome of this matter. So as it stands, per the move out statement that they received in the mail, we're seeking $646.55 in addition to the $500 security deposit.
Anything else, sir?
That's all that I have at this time.
Mr. Cordora, did you have any questions for Mr. Sigatura?
No, I don't believe so.
Ms. Cordora, did you have any questions for Mr. Sigatura?
No, I don't have any questions.
Sir, I have just a couple of questions for you.
Yep.
I reviewed the file and it shows that the Cordors moved in July of 2018.
Yes.
And you're saying that the pictures that you submitted to the court show damage to the walls or the paint beyond which would be expected after 3 years of tenancy?
Yes, Your Honor.
And the carpet, do your records reflect when the carpet was last changed out?
I do. I apologize. I thought I submitted that as well, but the carpet was installed in June of 2017. There was one prior resident to them that lived on the carpet, again, with no pre-existing damage. So the
Anything
carpet,
else on behalf of Southport, sir?
no, just that puts the carpet at 4 years from install to when they moved out. And I have nothing further.
Thank you. Which one of the Cordors would like to testify first or testify in this matter?
I can go first.
Ms. Cordora, raise your right hand for me, please. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Please proceed.
So we feel that we left the apartment in good condition, considering 3 years of tenancy. We cleaned, and everything that he's describing, that he's mentioned, I believe is just normal wear and tear. There was no major stains or rips in the carpet, no major damage to the walls or to the paint, just normal wear and tear. And I don't believe that we should be held responsible for them, doing what would be normal maintenance to an apartment after someone leaves, when they've been there for 3 years. Repainting the walls is typical, and getting new carpet or cleaning the carpet, those are typical things that landlords do between tenants. And so I feel like they're charging us for the typical cost of maintaining a rental property.
Anything else, ma'am?
I also want to, I didn't speak to the stove. I also wanted to speak in regards to the stove that, I would estimate that the stove is at least 10 years old, if not older. So that, again, also normal wear and tear for a stove that age. And I would expect that it was at a point where it would need to be replaced for new tenants, as was pretty much, a lot of the appliances in the apartment. They were older appliances.
Anything else, ma'am?
No, nothing else for me.
Mr. Secretary, do you have any questions for Ms. Cordor?
I do not have any questions.
Thank you. Mr. Cordor, do you intend to testify this afternoon, sir?
There's only just one thing I can kind of add to hers.
Raise your right hand for me. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please proceed, sir.
Okay, it's just some echo.
Are you all you all might be too close to one another.
Mute yours and just talk through mine.
Oh,
Now you're muted.
Okay. Okay, can you hear me now?
I can. Thank you.
Okay. Okay, great. The one thing that I just want to testify was about, I guess, the leftover rent that we're being charged for. Basically the notice that we got that I don't know if that was, yeah, that was sent in with the video, was that we owed $60 and I guess 58 cents. And when we paid through their portal that Southport has, it said that this is what we had to pay that was left. And so we paid that, and we paid what we said we paid. And I guess that I guess that's what we kind of don't understand. You know, if 2 days past is $60.58. And that's the payment that we put in. So I guess we're not understanding why there's another $60.58. So we exactly paid what we were supposed to, but then this is being added on. And so I guess there's some discrepancy about that, and we don't understand. I guess we don't think we should pay that extra amount because we paid what it is that they told us to pay.
Okay. Anything else?
No, I believe that's it.
Any questions for Mr. Cordor, sir?
I don't have any questions for him. I can clarify the $60.58, if this is the appropriate time to do so.
1 second. Mr. Cordor, Mrs. Cordor, any other witnesses or any other information you want to put forward in this case?
I guess I think Cyril kind of alluded to this, but again, we did get a move out letter that told us what our move out balance would be, and that is the exact amount that we paid, and we got verification through the portal that we paid that amount. So I just wanted to reiterate that.
What move out letter are you referring to?
A letter that Southport sent us. I believe the letter was dated
It's May 6th.
May
Oh,
6th.
Sorry, May 26th.
May 26th. So after we put in our notice, they sent us a letter, a move out letter, and they told us the amount of rent that we would have to pay for July. And that was the amount that we paid. That was also the amount that when we went online to make our payment, it reflected that exact same amount. And so we paid, you know, in good faith, what we expected was our rental amount. When we received a notice from them about these charges, they included a $60 charge for rent, when to our understanding, we paid all the rent.
Anything else?
No, that's it.
Thank you. Now, Mr. Secretary, you're going to clarify something?
Yeah, if you should have a copy of that May 26th letter they're referring to. It's a letter that
I've located it.
it's a letter that we send in response to a notice to vacate when we get it, to advise a resident that's moving out, you know, what their obligations are. If you see that, I believe I highlighted it in the middle where it gives the charge, it's rent due after move out through 7/4, July the 4th, is $60.58. So that's rent that they have due for July 3rd and July 4th to complete their notice to vacate. What they paid was the $60.58 is the exact same amount that they paid, because it's 2 days worth of rent. They paid through July 2nd, which was their move out date. Am I explaining that so that it makes sense? So
No,
they're,
it did not.
okay, I mean, their lease is through July 2nd of 2021. So they're responsible through July 2nd. 2 days of rent is $60.58 through July 2nd. They paid that portion of their rent. In addition to that, we're charging them through July the 4th to complete, to satisfy their full notice to vacate. So they gave us notice on May 6th. They're responsible for rent 60 days from that point, which takes you to July the 4th.
I'm with you now.
So it just happened that it's both 2 days. So I think that's where the confusion kind of falls in, where they're thinking they paid that balance. It's actually another 2 days that they're being charged for through July the 4th. They paid through July 2nd. They're responsible through July 4th.
Mrs. Cordor, was that a satisfactory explanation?
What I don't understand is why the letter didn't tell us to pay $120 and some change then, if that was the case. Because my understanding of that letter, it was telling us what we had to pay for July. So they came up with the figure of $60 and some change. I think it's 58 cents. It feels like it's a mistake on their part where they miscalculated what should have been paid. Or what should have been charged, I'm sorry.
Okay,
The letter indicates, I guess it just indicates on the letter that it's rent due after move out through 7/4. That's why it doesn't include the you told us you were moving out on July 2nd. So you understand that you have to pay through July 2nd. We're advising you what's due in addition to that. So that's why it just says the $60 and not, it doesn't calculate for your lived in rent, what we call it, while you're living there, because that's assumed that that's due on the first, like every other rent payment, I guess. We're letting you know what the obligation is after you vacate, and that's what the letter indicates.
Is it okay for me to talk, ma'am?
yes, ma'am. But
Okay.
before you do, were you still wanting to show the video?
Yes, I can show the video. Should I do that now or?
You can ask your question first or make your
Sure.
comment first.
Okay. So in regards to what Mr. Sigatori just said, in addition to the letter, there was also the payment that was processed in their payment portal. And when we made that payment, it only allowed us to pay $60.58. That was the final amount that we were given. So not just the letter, but also the payment processing portal that we use to make our payments. It did not tell us to pay $120. So we were never notified about this additional $60 until after we had moved out. There was nothing that they indicated to us that there would be this additional charge. And there was no way for us to have paid an additional charge because we made payments through their payment processing and it gave us an amount and we paid that amount in full.
Okay.
And then
So,
I
ma'am,
can, oh, I'm sorry.
I was gonna say, you can go ahead and hit share screen and start the video if you have it queued up and ready to go.
Sure. And are you guys able to see my screen? Yeah, is it showing you my screen?
Yes,
Okay.
ma'am. But we can't hear it, and I know that you're talking to the representative at this point in the
I would
video.
say my assessment right now would be carpet and your walls. So you.
Are you able to hear it now?
Your forwarding address,
Yes,
correct?
ma'am.
Yeah, okay, so you'll receive a copy of your move out statement to that new forwarding address, again, mailing time is 30 days. So just allow, and the mail runs really slow, so I would allow about a week after the 30 days. And then also don't mistake it for junk mail because it'll only say, our PO box up in the upper left-hand corner, so it'll only say PO box 2012, Louisville, Michigan 43. So I don't get a lot of mail, so I like rip a lot of stuff, so that's true about statement. If you don't receive it, like I said, within that time frame, you can always call corporate and they can email you a copy. All right, any other questions?
No, that's
Okay,
it.
you guys are all set.
All right.
You're very welcome. Have a good day.
Oh, yeah.
Now, there was a glimpse of that woman at the very beginning of the video. What is her name?
I'm sorry, I don't have her name. She was one of the leasing agents.
Okay.
I know her
Anything
name
else?
if it's something you need, Your Honor.
It was just I was just curious. It's not really, as long as you recognize that as a person who works at Southport, it's not really pertinent to me other than,
Yes, that's our one of the assistant managers there, Your Honor.
okay. Thank you for sharing your screen, ma'am.
You're welcome.
Okay. Anything else on behalf of the corridors?
Nothing else for me.
Plaintiff gets the last word. Anything else on behalf of Southport?
Just a couple of quick things, Your Honor. Again, as far as the rent goes, I think the letter, while it's a little confusing with it being 2 days and 2 days of rent, I think the letter clearly states that it's rent due after move out through 7/4. And then as far as the damages go, they were determined to be beyond normal wear and tear based on our experience with turning over apartments after people move out. When our painter has to do additional coats of paint, that's something we would consider over and above normal wear and tear. The stove, I think their video showed the exact same condition of the stove that our photos show. Again, that's something that wasn't cleanable and what we determined was beyond normal wear and tear, not something we normally see. Same thing with the carpet. You could see the dark areas of the carpet in the video as well as that matched up with the photos that I've provided. Again, same situation. We felt it was beyond normal wear and tear. And again, we take into account the age of a carpet and normal wear and tear when prorating, depreciating the cost of that carpet. And they're being roughly charged about 50%, I think, of what the carpet was, or 55%, somewhere in there. So that's all that I got.
Thank you. This court did have the opportunity to review the video in its entirety as well as the documents that were provided by Southport. And after listening to the testimony of the parties, court will find that there are damages to the apartment beyond normal wear and tear as relates to the stove and as relates to the carpet. This court will find that based on 3 years of tenancy and the photos and the video provided, that the paint does not show excessive wear or tear. Plaintiff's original claim was for $1,146.55, which included the retention of the security deposit. This court will enter a judgment in favor of plaintiff and against defendant for damages of $456.55. Subtracted from that will be the $500 security deposit that the plaintiffs are holding. There was a $50 filing fee. And do you have a service fee handy there, sir? Or is it just the certified mail?
It was certified mail, Your Honor.
Okay. This court will enter a judgment with those dollar amounts. Anything else on behalf of Southport?
Just to clarify the judgment amount, we're retaining the 500 and they'll owe us the 456.
Correct.
Okay, I just wanted to clarify that. Thank you.
Okay, I'm sorry. I guess I'm a little confused. What's the total amount that we owe to Southport?
The judgment will say $946.55 plus court costs. But you will receive credit for the $500 security deposit that's being retained because they brought this suit in response to your dispute of the security deposit information sheet, itemization sheet. So
Okay,
this was about retaining the security deposit and the damages amount due beyond the security deposit.
okay.
Did that clarify?
Yeah, so, I'm sorry, go ahead. I guess I should let you finish first.
I wasn't saying anything else. I can tell you're going to ask another question.
So are we going to receive like an invoice from the court or from Southport as far as what we have to pay in addition to our security deposit?
You will receive a judgment
A judgment, okay,
that says $946.55 plus the $50 filing fee. And there'll be some indication on there that the plaintiff will retain the security deposit.
okay,
Okay?
okay.
Anything else on behalf of Southport?
No, Your Honor.
Anything else on behalf of the courtors?
No, Your Honor.
No.
Thank you all so much for logging on this afternoon. We'll get the judgment prepared and mailed out to the parties. Everyone have a good afternoon.
Thanks, Your Honor. You too.
Thank you.